Thanks, everybody. We'll give the queue a few minutes to fill the conference space, and then we'll go ahead and get started. Okay, as people are filtering in, I'm going to go ahead and get started. Thanks for joining us today. We've got what I hope is a useful presentation talking about reviewing service agreements from a retirement plan perspective. A couple of housekeeping notes before I get started and jump into the intros. First of which is your lines have been muted. We encourage participation, so there's a Q&A window. We'll try and address questions either as we're going or potentially if they're more expansive than we're prepared to answer now, potentially after the presentation is over. We are also recording today's presentation. So while obviously any notes you want to take are perfectly welcome, do keep in mind that we'll be providing to those in attendance a copy of today's presentation as well as a copy of the recording. So to the extent that you will need to go back, listen to that again, distribute it to others within your organization, you'll have the ability to do so. I want to start today's presentation by introducing the two of us. My name is Eric Daly. I'm a managing principal with Multnomah Group. We're a retirement plan consulting firm headquartered in Portland, Oregon, and I'm joined today by Stuart Harris, a partner at Davis Wright Tremaine, who works extensively in the ERISA practice. And while periodically I may pretend to practice law, I am definitely not a JD. And today's presentation is going to touch on a lot of the responsibilities and contractual law components that we see as we stand alongside our clients. But Stuart will walk us through the various ins and outs of those agreements and the things that you should be mindful of and watching for when working on your retirement plan record keeper engagement specifically. Today's presentation, we've kind of broken it into 5 different sections. We're going to talk a little bit, I shouldn't say where, because I'm not going to talk about it at all. Stuart's going to talk about contract law basics. We've got one of our employees is in law school currently. I think that's actually a class. So maybe Stuart can take us back to his law school days to walk us through the basics of contract law. Stuart and I will both talk about the ERISA considerations, the Employee Retirement Income Security Act, and how they interact ultimately with contract law. The best time to have leverage in the contracting process is before you've executed the agreement. So we're going to talk about some best practices to try and get the type of retirement plan service agreement that's most conducive to the protection of your organization, your participants, and how do you get that leverage with your record keeping provider. We'll talk a little bit about how to review the contract that you have. I'm going to presume that the majority of folks on the call have retirement plans today. Those retirement plans are under some form of contract. And as a result, knowing what the contract states and where you stand today, I think is also important. And then we'll kind of walk you through some to-dos or a quick checklist of things that you may want to consider or work on as we leave today's presentation. Like I said, I'm going to throw the contract basics class with Professor Stuart Harris off to him to talk about. So Stuart, maybe I'll let you kind of talk through contract law basics.
Sounds good. Thanks, Eric. And you could definitely play an attorney on TV. You got the right image. You're right. Pretty much every law school that I know of, first year, one of the required classes is contracts. And so, basically contract law is the rules of the game for just governing business transactions and other transactions as people say, an economy likes certainty. So the purpose of contract law is to provide certainty to parties as they engage in transactions so that they can know the outcome and they're more likely to do stuff. At pretty broad overhead there, or overview. So a contract, basically an agreement between two parties. It's different, and this will sound maybe a little professorial, but been my dream to be a law professor. It's different from a promise, because a promise is just something that someone makes. I could promise Eric, say, hey, I'm going to take you out to lunch. But he couldn't sue me for breach of contract if I never call him up and take him out to lunch, because that was just a promise. A contract's really a commitment between two parties, and there has to be something called consideration. And consideration is just the legal term for the stuff of value that both people are giving. So if Eric were to say, hey, I've got some Blazer tickets, I'll give you these tickets if you promise to take me out to lunch, then we might have a contract, because both of us are exchanging something. And for today's purposes, typically what's being exchanged is services. Your record keeper or some other plan service provider is committing to provide certain services to you in exchange for payment. And so that's the kind of the consideration flowing both ways. So contract, you need a document. Now, technically, you can have a verbal contract. A contract doesn't have to be in writing, but it's always a good thing to have it in writing. And one reason for that is that, and you may see this as you look at your service contracts, there's a provision often in there that it'll say, this represents the final understanding of the parties. And sometimes it might even say integration clause. And what that means is that we've had a bunch of discussions leading up to this final contract, but the purpose of this final contract or this final agreement is to embody everything that we've agreed on. And if someone wants to then come back and say, hey, no, I thought this was our understanding, you point to the contract and say, no, everything that we agreed to is in this document. So again, if I promise to take Eric out to lunch, and then I do, and I take him to McDonald's, and he says, I thought we were going out for a steak dinner, I would say, well, that's not in the contract if we had written it, but it's very unlikely we're going to enter into a written agreement to go to lunch. And so when you have a contract, what can happen is that someone doesn't hold up their end of the deal, then that's called a breach of contract. And you've got potential damages. I'm not sure what Eric's damages would be, just saying, hey, I missed lunch and I was really hungry and hangry the rest of the day. But in other situations, you could have some real damages where if someone doesn't do what they're supposed to do, and then typically the contract would also acknowledge or specify what are the consequences of a breach, what are the potential damages there. Indemnify or indemnity under the contract. That's something that also is, it's related to damages, but it's not so much, if one of the parties doesn't fulfill their side of the arrangement, an indemnity saying, here, look, I'm going to enter into this contract, but I want certain protections. So again, it's maybe a silly example, but Eric and I have a contract that I'm going to take him out to lunch. He might want to put in there, you're going to take me someplace decent, not a sketchy food cart that doesn't look terribly sanitary, because I don't want to get sick. And if I get sick, you owe me something else. You might owe me another lunch, or you're going to indemnify me for losses that I might experience. So that's another element that you frequently see in contracts. That's a very couple minute summary of contract law, which I did not do justice. But we'll move on to the next slide. So another implication in the area that we're dealing with, so with retirement plans and employee benefit plans in general, the contract process is influenced to a degree by ERISA, the Employee Retirement Income Security Act. And kind of two overriding principles there's a section of ERISA 404A, which says that a fiduciary, who typically a person who's going to be a fiduciary for plan purposes, has the ability to administer the plan or to arrange for commitments that the plan's entering into. And they need to act for the exclusive benefit of participants and their beneficiaries. So they're supposed to have a sole focus. That's their purpose. They're not looking for any ulterior motives. Again, using my silly example of lunch with Eric, if I'm taking Eric to a really nice lunch, and I'm going to pay for it, but it turns out I'm taking him to a lunch of a friend who's trying to build up business, I'm maybe getting something else out of that. Or maybe this friend has said, look, I'll I'll give you a free lunch, Stuart, if you bring a client or a friend to this lunch, buy a big steak dinner at this restaurant, then I'll give you something else. So I'm getting something else in return. If I have a fiduciary duty to Eric to look out for his best interests, does that kind of muddy the waters there that I'm getting something in return? And we'll talk about kind of that principle. But again, principle number one is I need to, as a fiduciary, and I'm contracting involving the plan, I need to be looking out for the exclusive benefit of the participants and the beneficiaries of the plan. The second thing under ERISA that's relevant here is that I have a duty to act prudently. So that means I have to be reasonable. I have to act in a fashion that a normal, prudent person in my situation would act. And so that's another requirement under ERISA. ERISA also has a set of rules known as the prohibited transaction rules. And what they say is that individuals, if I'm a fiduciary, I have to be careful that the plan is not entering into certain business or business-like transactions with parties that have a close affiliation or a close relationship with the party or with the plan. And the reason for that is that there's a concern that if you maybe are an insider, so to speak, or have some sort of special relationship to the plan, you could use that relationship to take advantage of the plan, to kind of shift how benefits are being provided. And so that's considered a prohibited transaction. Now, prohibited doesn't mean that it's kind of an ominous sounding term. It doesn't mean that they can't happen. It just means that there's a penalty that can apply. An example for that would be most retirement plans, lots of 401k plans, for example, have a provision that allow for a plan loan. And technically, if I'm a participant in a plan, I have that insider type relationship. And if I want to take a loan from the account, that is technically that's a prohibited transaction because I'm doing this business-like transaction with a plan that I have a relationship with. And so a fiduciary should said, we shouldn't allow Stuart to borrow money from his 401k account. However, there are exceptions to the prohibited transaction rules. And so, for example, I can, as a participant, borrow money from my account if certain things happen. I have to pay a reasonable rate of interest. The loan has to typically be secured by a vested portion of my account balance, probably rules that most everyone is familiar with. So that is a prohibited transaction. I use that as an example, but then there's an exemption for that allows it if certain things are done. Similarly, service providers to a plan kind of fall into that category of insider-like individuals or parties, and they could be subject to the prohibited transaction rules. But again, there's an exemption if what they're being paid for to provide the service is no more than reasonable compensation. So that's why you, as a person of influence over the plan who's negotiating vendor contracts on behalf of the plan, need to say, well, we want to make sure that this is not a prohibited transaction. And the way we do that in this context is to ensure that what's being paid to the service provider is no more than reasonable compensation. And one way, you have to know, well, what's reasonable? What's market out there? What are people paying for these types of services? And obviously, an RFP or an RFP every few years, that sort of thing will show what's reasonable, what's in the market out there. And so at the outset, you probably ought to get an RFP, and it's like they say, you're doing a home remodel project, get 3 bids, find out what's the range of what people are charging.
Yeah, thanks, Stuart. I do think that RFP piece is really critical, and we're seeing maybe in part as a result of some of the class action litigation that plan sponsors have been facing. But this reasonableness requirement that Stuart mentions has obviously always been in place. That's a DOL requirement. Whether the DOL enforces it or whether the plaintiff's bar enforces it is a different issue. And I do think that we are finding more frequently now that the plaintiff's bar seems to be the primary enforcement mechanism for some of the fee reasonableness issues. And I do think that there is tremendous merit, right, that is achieved by plan sponsors and fiduciaries through going through the vendor search process. One of those has to do with your ability to negotiate more favorable contract terms that we'll talk about. But it's also true that not going through some type of procurement process for your record keeper can carry risks. There's been the Banner Health case is probably the most frequently referenced case. And the Banner Health case, Banner was tremendously successful in fending off a plurality of claims that were made by the plaintiff's bar against their case. And when the case made its way through the courts, really the primary method and the primary issue that was identified by the court was that in this particular case, Banner Health had not run a record keeping search or an RFP for their record keeper over the course of the last 20 years. It wasn't a huge finding in favor of the plaintiffs. And Banner Health had a myriad of other practices in place to try and ensure the reasonableness, but sometimes those additional opportunities outside of an active, engaged search process are insufficient. So I think many plan sponsors, maybe the majority, go through some form of fee benchmarking on a periodic, even annual basis, where effectively they take a look at the cost of the services that are being paid for by the plan and compare that to some reasonable benchmark based on size and the availability of data that's in the marketplace. That certainly allows a plan sponsor to kind of monitor the reasonableness of fees over an annual period of time. But again, without that competitive environment, may be limited. We're seeing some clients go from kind of an enhanced benchmarking to what we call a request for bid, which is incorporating some limited information, not doing a full-blown qualitative review, but looking more finite, focused on the economic the opportunities that are out there from a record keeping administration perspective. But again, for the majority of receiving the best amount of leverage, even with your incumbent, and at looking at the variety of record keepers that are available in the marketplace, a comprehensive RFP process is going to generate the best and, again, most defensible, I would argue, process against a potential fee reasonableness and service reasonableness case, right? Reasonableness sounds like a specific term. Regrettably, it's not, right? I will say the reasonableness isn't lowest possible cost. It isn't anything along those lines, but being able to draw, which can really only be done the most effectively through a search process, this combination of here is the cost of services, but this is the variety and quality of services that we're going to be receiving in comparison to other options and other combinations of cost and service quality is going to be, again, the most rigorous defense against a reasonableness breach case. Just to give you a sense, I do think that it is not uncommon. Well, let me say it differently. Instead of using a double negative, it is common that plan sponsors do not want to go through a search process for a record keeper. It is time consuming, it is disruptive, it costs money. And if you are otherwise very happy with the services you're receiving, it seems to be of very little ultimate benefit to the end participant shareholders. And I don't dispute necessarily any of those claims in a situation where you may otherwise be happy. I do think it's important to point out that through a search process, again, the overwhelming majority of searches that we see end up retaining their incumbent. We did 24 record keeper searches over the course of the last 12-month period of time, and about 50 to 60% of those organizations elected to retain their incumbent. However, going through the process in almost every one of those cases resulted in a reduction in the operating costs of the plan, and frequently enhanced services, even in the case where those clients elected to retain their incumbent. So when you look at a search process, I do understand that it takes time and that all organizations are stretched from a resource perspective, especially as it pertains to the expertise that you're going to be borrowing from finances, human resources, and benefits in the execution of the search. That process is typically going to take somewhere in the neighborhood of 6 months. And I do think planning out a search process so that it's not hitting on other peak times that your organization is also going to be utilizing those resources is going to make it a much less painful process. I would also point out that the search process itself, if outsource to a fiduciary organization to help you run that process is actually not overly dramatic from a HR utilization perspective. Much of that can be outsourced to third party. Where it becomes very, very difficult from a record keeper perspective is in the event that you make a decision to depart one record keeper to the other. The first 6 months from stages 1 through 5 is a relatively light lift. That last stage, stage 6, which incorporates the transition of data, the notification of participants, the changes of payroll feeds and other things, is the part that can take in and of itself another 6 to 12 months, depending on the complexity of your plan. But a good search process really starts with identifying what the goal of the search is. Is the goal to compare where we are currently, which is otherwise happy with other record keeping service providers, and evaluate the cost of that happiness? Or is it to fix a broken problem with our relationship with our record keeper? Once we've identified that, developing an RFP, and we're going to talk about some of the things that may be included in an RFP that can help support that contracting process. Having an open process for soliciting proposals that you can compare easily from one to the next. Choosing a subgroup to get into more detailed conversations with, and ultimately selecting a record keeper. When you get to the point of making a selection, however, and I do think this even feeds back a little bit to the development of the RFP process, it has been our experience that from a best practice perspective, negotiating the terms, or at least articulating the terms that are important to your organization, both from a service and a contractual perspective, is best done early in the process. Trying to do that, and this really gets back to Stuart's comment about negotiating where we're going to go out to lunch after we've already agreed to go out to lunch. He's already offered, I've already said yes. So for me to go back and say, well, now that you've offered to take me for lunch, let's talk about the minimum standard of what I would be consider appropriate from a lunch outing, is probably a little late in the process. If Stuart says, hey, do you want to go for lunch? The right time is when I decide whether I want to go or not. Say, well, I do, but I only want to go for lunch if it's going to be at 11:30 on a weekday and at a restaurant that has at least 4 stars on Open Table. And that's my criteria, and it can't be more than 20 minutes from my office. I think there's 2 areas ultimately that if you're looking at developing an RFP to try and drive outcomes. I'm going to talk about the record keeper service piece and let Stuart talk a little bit about the contractual issues. I think it's really important to talk about direct and indirect compensation and how the service providers you work with collect, record, and document indirect compensation. It's an area of litigation. Frankly, the amount of indirect compensation where interest rates are today is higher than we've seen it traditionally at other points in time. That indirect compensation is significant, and articulating how you expect it to be handled, I think, is something that you would want to get them to agree to at the beginning of the process, as opposed to after you've fallen in love with the service provider. How to address issues and over what period of time and what responsibility does the record keeper have? Record keeping is a really difficult business. We're moving lots of dollars and numbers around in a system, and it is not atypical for a record keeper to periodically make an error. The question becomes how quickly and who's responsible for remedying errors that may occur as part of normal course of business. What are your employee communication requirements is a big component. When you look at variability in cost of record keeping, administration, and employee education services, the amount and how you wish to have employee education delivered tends to be a huge variable in the cost component. If you're not right sizing those expectations at the beginning of the process, you're going to have a hard time arguing them in the contracting process. And last is trying to incorporate whatever service level agreements you think are reasonable given your plan, whether those have to do with quality, accuracy, timeliness, or some other metric. Again, asking your record keeper to ultimately get to a point where they can provide you service level agreements after you've already elected to hire them is probably the wrong time to try and work through those issues. But Stuart, I'll let you maybe speak to some of the contractual issues that you can also define as part of an RFP process.
Yeah, will do. So standard of care, and we're going to talk about this a little bit more, but, do they have, what constitutes a breach? If they're negligent, if they're grossly negligent, If they're willful, if they purposely, make a mistake, that's something that ought to be addressed in the contract. Limits on liability, we'll talk about that also a little bit more depth, but, typically the service provider will want to cap, what's their liability for making a mistake. And what sort of indemnification do you, as the plan, have to give them should someone come after them as a service provider. Department of Labor cybersecurity compliance. That's a hot topic. The Department of Labor has talked a lot about cybersecurity, although it's a little unclear exactly what needs to be done, other than people need to work on protecting information and safeguarding it from hacking. And so in the agreement, you want to have some commitments, have something that clearly says what are they doing in this regard. Typically, you'd want to also address in the agreement that your service provider is not going to sell participant information, or if they are, what that's going to look like and what's going to happen with it. But typically, you don't want that to happen. Obviously, you want them to keep this information confidential. They're not going to disclose anything. If they're going to use subcontractors to carry out their services and fulfill their obligations under the contract, you want to know that, and you may want to have some say. In fact, you may want to say, I don't want you subcontracting out because we're specifically picking you, and we're comfortable with that. We don't know, what other parties might be. Insurance requirements. You want to know that your service provider has insurance, because if things go really bad, and you have some losses that you need to recover from, do they have adequate insurance that's going to step up and maybe fill that gap? We'll also talk a bit in more depth a little bit later about kind of termination provisions. What kind of notice has to be given you as the plan sponsor, if you want to get out of a relationship, or them as the service provider, if they want to get out, you want to make sure that they have you want to be able to get out somewhat flexibly if things just are going badly. But at the same time, if they want to get out of the arrangement, how much notice they give you so that you're not kind of left in the lurch. And then finally, the agreement should talk about resolving disputes, the where, when, and how. It's one thing if an agreement says, all disputes will be completed through arbitration in New York City. Well, if you're here in Portland, Oregon, that's a more expensive proposition. And so you may want to try to negotiate that to make it more of a reasonable, more conducive process than what the service provider may want.
So if you've been able to successfully kind of tie those things into a procurement process, again, the time that you probably have the most leverage with both your incumbent and anyone, obviously, that you may elect to hire, likely you're going to get to the point of either re-upping with your current provider, selecting a new provider, and inevitably that kicks off this contracting process, right? We either renegotiating the contract that's in place or starting with a new contract that's there. I do think this is a part that gets blown through maybe too quickly frequently with plan sponsors, which is, well, they made a lot of promises in the finals presentation. I trust and like the team that made that presentation. I assume these contracts are boilerplate, and as a result, I kind of go through this process. And frequently, regrettably, we find that record keepers don't provide adequate time for clients to do a thorough review of the contract, right? This is a really big decision that's impacting hundreds, thousands, tens of thousands of participants, millions, tens or hundreds or billions of dollars in assets. Making sure that we're comfortable with the contract makes sense. So making sure that the contract complies with whatever internal supply chain protocols you have. If you're working with procurement, from the issues procurement identified combined in that document. Have you socialized that internally with in-house legal and your privacy security teams for those that have them? Are you aware of the deadlines, how the contract execution may impact the timing of a potential conversion or the start of a new contract? Do you have access, and do you know who the right signatories are? Like, who is the one executing the service agreement on behalf of the plan? And in that case that it becomes necessary, and frequently I think it's certainly advantageous, have you connected with your outside counsel? And, as outside counsel, Stuart, maybe you can speak to the things that you do on the outside counsel side to make sure that these agreements are in place.
Yeah, and maybe just a few hot topics. You know, it's possible, not often, but it's possible that, as your outside counsel may have a conflict. So if they've done work for the service provider, uh, they may have to get a waiver of a conflict there. So my recommendation, my request from clients is, send me the whole agreement so I know who we're bargaining against. Like, occasionally, I think, clients may want to say, we want to keep the legal bills low, and that's completely acceptable and understandable. So we'll just send Stuart a provision. Well, if that provision then generates some discussion, some negotiation back and forth, I might be in effect negotiating on behalf of a client against another client. So I really like the whole agreement, so I know who's on the other side and I can run the appropriate conflict check. Also, let me know what level, let your outside attorney know what level of review you're looking for, because it may be that you have an in-house team that's looked at this, that's done a lot of negotiation, and maybe you only have one or two questions, the dispute resolution provision or the indemnification provision. And you can say, look, we're comfortable with the rest of this. Can you do a quick review? But here are the two areas we'd really like your thoughts on. And then just discuss timing. As Eric mentioned, sometimes this process can go, can take a while. And where is the client in the timing process? Are they right at the end? And so I, as the attorney, outside counsel, I'm the one that's holding up the show, so to speak, or is this early on? And, I have a couple weeks. So those are the things that I think often become some friction points when you're dealing with outside counsel on these contracts. In speaking of the contract, so some items again for review, you want to make sure that the contract accurately, and this sounds maybe almost silly or childish, but that it's naming who you are as a party and who the plan is. Occasionally we'll see that and it's like, oh, they've got this wrong, or they pulled a DBA, a kind of a business name off your website, but it's not the official name of the company. A description of what services are you looking for. Again, as Eric mentioned, sometimes these contracts can be fairly boilerplate, just kind of standard. I recently reviewed one where it said, we'll provide the services on Exhibit A, and then you looked at Exhibit A and you're like, this isn't really what you're wanting at all. So, look at it and make sure that it's what you want. Performance guarantees, that's something, are there things that they can commit to, timeliness, no more than X% errors, or errors will be resolved within a certain specified period of time. What does the contract say? If it doesn't say what you want it to say, you can always ask. Typically in the contract, they'll also ask the employer to make certain representations, for example, that their plan document is qualified, that they're on, say, they may be on a prototype, a pre-approved language plan, that they have a favorable opinion letter from the IRS. Are those things true that you're representing? Also, there might be certain obligations for providing information to the service provider and timelines that the vendor wants. Can you meet those timelines? Is this a process that can be workable? Again, that means you got to read the contract, say what's expected by us. Payment mechanisms, deadlines. Is this going to work with your procurement process? Just make sure that it's consistent with the way you're doing business and you're prepared to do business. We'll talk about fees a little bit later. But now in the termination provisions, is there enough time? Are you comfortable that if you want to exit, how much notice do you have to give? If you find out it's just not going well, we want to pull the plug. And similarly, if they don't like you, how much advance notice do they need to give you so that you can find replacement services? Because again, you don't want to be held left in the lurch. Talking about want to drill down on certain legal provisions, refer to them as the big four. So the first one is the standard of care, that they're going to agree to act as a comparable, reasonable service provider would act. And typically the standard of care you're looking at is negligence, that if they do something that's negligent, that's going to be a breach of contract. Now, occasionally, and well, more than occasionally, you see this a lot, they'll say, we'll be liable we will be deemed to have breached our duties if we make a willful mistake, you know, if they are not even a willful mistake, if they do something on purpose, although it's hard to imagine why they would do that, but if they've got a criminal or, you know, kind of an element on their end, someone who's somewhat nefarious, or if they're grossly negligent. And I always strike out gross negligence because it's a pretty high standard, and it's a more of a vague standard. You know, what's the difference between negligence and gross negligence? And you can spend a lot of time arguing about that. And my response typically is, look, negligence means you made a mistake. If you make a mistake, I'm expecting you to fix it, not if you make a mistake that's really, really bad. On liability, often companies will say, well, you know, we'll be liable, but the most we can be liable for is, say, 1 year of fees. And maybe an example might be, you know, and often that's not going to be adequate. If I take my car to an oil changing service and they say, you know, we'll change your oil, but by the way, if we do something wrong, we're only liable for the cost of what it cost, you know, what you were going to pay to change your oil. Well, that may be what, $60. But if they decide to put oil, or mistakenly, negligently put oil in my windshield wiper filler and then put windshield wiper liquid into my, you know, into my oil canister, the motor oil, where the motor oil should go, I'm going to have a bigger problem than $60. And so you don't want to allow them to limit the liability. One way these discussions can go back and forth. One way to handle that is to ask them, well, what's your insurance? I'm assuming and hoping and expecting that you as a vendor have errors and omissions insurance, and you tell me what those limits are. And maybe that's what we'll decide on, is that, you know, my ability to recover from you, it won't exceed the limits of your insurance. And there can be some negotiation there. I mean, certain types of errors could result in you know, greater amounts of liability. And if I'm the oil, going back to my oil changing scenario, you know, if I drive in with a vintage Corvette that could be worth a lot of money, I could see them saying, look, you know, if we mess this up, we don't want to have to replace that whole Corvette. That's just too expensive of a proposition. So we might, you know, we'll limit it to something less. But those are discussions, you know, the standard of care and limitations on any liability, those typically become some of the crucial points that are discussed in a negotiation. The next one, again, is the term. You know, can you, as the service recipient, can you terminate without a penalty? And with a, you know, what's the notice? Is it a reasonable period of notice that you can give out, or is it, you know, are you locked in for the entire year? Are you locked in for 2 or 3 years? You know, does the contract or the agreement align with your expectations? So you want to check and decide, okay, if we want out, who do we have to give notice? How do we have to give notice? Is it in writing? Does that make sure it's reasonable? And then on the other side, you know, if the vendor wants to back out of this agreement early, you know, am I having enough time that I can find a replacement service provider? Is the vendor agreeing to cooperate during a transition period? And that can be very important as you're transferring records back and forth. And will the vendor agree that for a period of time that they will retain some records, so that if a dispute does arise, say, or, you know, question, you have a question from a participant or even a Department of Labor investigation, I'm going to be relying on that. I might have to rely on that former record keeper to provide some information so that I can answer questions that are being presented to me. The next item is fees. And as we've talked about, you know, the fees need to be reasonable. And, you know, as Eric mentioned, you know, there are a number of ways you can assess reasonability, the benchmarking, but, you know, the RFP process on a somewhat of regular cadence is probably the best way to decide what's out there, what's being charged. You know, it's not unreasonable to have if you have to pay a fee for an early termination, but you want to know what that fee is, and make sure that that's there. You know, service providers often in these agreements, and it's kind of standard boilerplate that says, hey, we can increase the fees at any time, or with, you know, X number of days notice, 30 days notice. you'll want to look at that, because you want to say, look, if they jack the fees up really high, we want an opportunity to say, that's not okay with us. We're going to go find another vendor. And so you want time between, they're giving notice of the increase and your ability to get replacement services. The best standard, if you can get it, is that there's an agreed mutual agreement as to fee increases, so that they're going to come talk to you. There's going to be a negotiation, and you can come to something that you both agree to. Again, on the early termination fee, I think it's good to show that it was negotiated, and that's a way to show that it's reasonable. It's not just a standard boilerplate thing that you didn't question, and there wasn't really any back and forth on that. So if there can be if there is a fee for an early termination, try to negotiate it, and ask around, find out if that's reasonable or not. The final issue that we kind of lump into the big four is plan assets. Now, this may be one of the smaller ones, but sometimes you might be dealing, say, for example, with a 403B plan that has insurance contracts. So you technically don't have plan assets. And this may be also more of an issue with certain welfare benefit plans. But you want to make sure that the mechanism for paying, listing the account, and paying on behalf of the plan doesn't set up an arrangement that under ERISA is going to deem the plan to have plan assets, especially if you structured a plan in a way where you want to avoid the characterization of having plan assets. So to do that, you'd want to have language in the agreement specify that services are being paid with general assets. Sometimes it will say that it's the employer will pay the services, pay for the services unless the plan does, or the plan will pay out of general assets unless the employer steps in. And sometimes in these situations, you'd also maybe want a representation from the service provider that the payment mechanisms, not intended to establish or create the understanding that the plan has specific assets. So that concern doesn't touch every plan, but for plans it does touch, it's an important one.
Thanks, Stuart. I wanted to also point out that a number of these contractual issues feed into other requirements of the Employee Retirement Income Security Act. I think hopefully we've made it really, really clear that defining this best interest standard of reasonableness is a fiduciary standard, and why these contracts are important. However, it's also important to point out that as a byproduct of Department of Labor regulations, the contracts have become almost part of the disclosure process. So under Section 408B2 of ERISA, it mandates that service providers disclose information about services and compensation. Some providers have a disclosure document that they create independent and separate of the contract that fulfills 408B2. However, very, very frequently, record keepers point to the contract as being their 408B2 disclosure document. So as a result, again, one of our requirements under Section 408B2 is the review of that documentation, and much of that may go back to the original source document that defines the ultimate services and compensation received. So in looking at that, our responsibility as plan fiduciaries, certainly as independent fiduciaries and those for the plan sponsors who sit in that seat, is to review that particular piece. So if the service provider is using the contract as a disclosure mechanism, it becomes increasingly important that you have some process in place to periodically review that. Even in addition to that, I would argue that when we go through these search processes and try and get these service level agreements that Stuart was talking about, where we define what our expectations are, what we find frequently is we get lots of promises in the search process, and then over time, the monitoring of those commitments declines. So we have a service agreement that says providers are going to do the things outlined on Schedule A, back to Stuart's reference, and they're going to do it with these mechanisms if they don't do it correctly. And we discontinue the monitoring of that. We actually could potentially find ourselves in a place where our 408B2 is no longer accurate, where we say we're doing something that we're no longer doing. We're paying compensation for the thing we said we're doing. And it may not be consistent with what ultimately the obligations and requirements of 408b2 are. In looking at those record keeper service agreements, we do find, especially with smaller plans, that the record keeper service agreements are disturbingly ambiguous about the responsibilities of the record keeping service provider. If you're going to use a service agreement, well, in any capacity, but certainly as a 408b2 disclosure, it's important that you're very, very specific about the scope of services. So, for instance, one of the areas where we run into problems periodically is the extent to which compliance tests are going to be coordinated by the record keeping provider, and which tests are included in the scope of services versus which tests become out of scope and potentially may incur additional costs. Understanding your plan, defining what your testing regime needs to be, defining who is and how much they're going to be compensated for conducting those tests, I think is one of those areas where we see ambiguity that ends up hurting plan sponsors in the end, and they end up paying twice for potentially. Distribution of disclosures. Along with 408b2, we have 404a5, right, which is the responsibility of plan fiduciaries to disclose the fees for services to participants. That is in addition to a myriad of other disclosure responsibilities that plan sponsors carry. Could be summary annual report, could be your automatic enrollment notice, could be your QDIA notice. All of those responsibilities are fiduciary responsibilities. Very, very frequently, the record keeper is the one actually providing and distributing those disclosures. From a fiduciary perspective, as a plan sponsor, I want to know who is going to be managing my responsibility to disclose information to participants. And if it is my record keeper, that's contained in my service agreement, and I know what the mechanisms are if they breach that contractual duty. And last but not least, and we're increasingly seeing this with fiduciary work plans, I was working on one this morning, a plan fiduciary review of the service agreement. You need to go through every plan and provision, but no, do we need to be aware of those 4 issues that Stuart was mentioning, the big 4? Should we be monitoring the service level agreements and defining whether there are any changes that we should be asking for or any breaches that we've noticed in their provisions? I think that's true. I think, again, managing service providers who are providing record keeping, administration, and other services to the plan is a critical component of being a good fiduciary. You can't just hire someone and turn the keys over. So this plan fiduciary review, both of the quality of service, the cost of service, and the degree to which those things are accurately reflected in your current service agreement 408b2 notices becomes very, very important.
I'll just add on top of that, Eric, there are, both the IRS and the Department of Labor do routine audits of retirement plans. Sometimes they're targeted, sometimes they're just random. And especially the Department of Labor, if they come in and do what they call an investigation, they have a checklist of things that they always ask for, and they want to see plan documents, but then they want to see service agreements. And so they're going to look at that, and you will get some questions about, when was the last time you reviewed this? How was this negotiated? I think that the top of our checklist here, locate your contracts and related amendments. You need to know where they are, and they really need to be in writing. Because I've seen some situations where it's like, well, we've just dealt with these guys for years, and we trust them. That's great that you found people that you can work with and you trust, but the Department of Labor wants to see it in writing.
Along those lines, once you find them or get them drafted, to Stuart's point, if you're in their absence, evaluating and documenting, I think it's important to document, right? From a fiduciary best practice perspective, and I know many of you are aware of this, documentation is your best defense in the end, right? So you need to evaluate the reasonableness of your contract terms, but you also need to then document the reasonableness. We reviewed it, we looked at A, B, and C, we, through search, through benchmarking, whatever it may be, are comfortable in our standard of care. We're comfortable in the term, we're comfortable in the fees, we're comfortable in the services, we're comfortable that we're not creating risk on the plan asset side. If you're not comfortable with any of those elements, and even periodically, if you are comfortable with all of those elements, audits, I do think it's important, again, go through a process by which you can define, refine, and measure those service terms. So in some cases, periodically it's fee benchmarking, but at least on some recurring basis, going through a full vendor search process where you can get the most well-articulated review of fees, services, and competition, and therefore providing the most favorable leverage to the plan sponsor with whomever they may be contracting with.
A phrase you've
yeah.
often heard, sorry to interrupt, Eric, the courts will use is procedural prudence. I mean, as Eric, as you said, no one has a crystal ball, and you can't, go over everything with a fine-tooth comb. But do you have a process in place for reviewing these things, reviewing the agreements, assessing their reasonableness? And most importantly, was your process reasonable, and did you follow it? And if that happens, if you had a reasonable process and you followed it, that's really, you're going to be your best defense.
And last but not least is there are a number of, again, notices that need to be distributed to participants, some of which touch on issues related to contracts and costs and services. There certainly are a myriad of notices that are typically distributed by record keepers, ensuring that those disclosures are being made. That, again, the fiduciaries are reviewing the contract, the fiduciaries are ensuring that the disclosures are made to the appropriate parties, whether it's the Department of Labor through the 5500, or whether it's to a participant related to a summary material modifications on a prototype plan document change. Those are all areas of potential risk that you want to make sure that you've reviewed and executed efficiently and accurately and documented well. Before I open up for questions, I think Price, Stewart, and I would be remiss if we didn't provide some appreciation to Deepa Sudra, who may recognize some of this content. Is she was instrumental in helping us develop and build out the framework here.
She's one of my colleagues, so it's not plagiarism if she said you use her stuff.
It's in-house, exactly. Yeah. It's in-house. I want to open it up for questions, give folks a chance. We're at 7 till the hour. Give everybody a chance to type out any questions they may have. Again, very, very appreciative of your time. Hopefully that there was some information here that you can take back and will be applicable to your organization, your plan, your fiduciary process. But I'll give it a couple of minutes. I never know how long to leave people the time to type versus not. But let me give it a couple minutes before we call it a day.
And Eric, while they're typing, you and I can be thinking about how we want to negotiate our next lunch, because I've got a whole new set of thoughts now.
I got terms now that I can negotiate.
I mean, 4 stars. Agreement. Come on, gee.
Conversation has to be at a certain level of quality. Okay, I'm gonna call it. Appreciative of your time, and do keep an eye open. We will have copies of the slides and a link to the recorded presentation as well. Thanks again,
and
Stuart, for your work.
And I'll add, if someone has a question, if I was unclear or maybe confusing about something, feel free to shoot me an email. I'm happy to respond that way as well.
Great. Thanks, everybody. Have a wonderful day.